Good afternoon, Mrs. Winston. I was pleased to meet with you several weeks ago to talk about your objectives and your expectations. The information you provided to me at that time has since allowed me to prepare an evaluation, and I've developed a plan that I'm confident will meet your objectives and move you to the financial peace of mind that you're seeking. Let's talk about estate planning in detail. At our first meeting, you asked me to review the strengths and the weaknesses of your current estate plan. Frankly, I did find significant deficiencies, but the good news is that they can all be remedied very quickly, very easily. First, you tell me that you do not have a will currently. My first recommendation is to get a will created. You will need to work with an attorney to draft a will, and as discussed at our initial meeting, I will let you know when I'm outside of my area of expertise, which is in this case. Given the complexities of the legal matters involved with drafting a will and the other documents we will discuss, I'm happy to refer you to a colleague of mine who has a focus on estate law. I do not receive any referral fees for that, so there is no conflict of interest. And of course, you may seek your own attorney if you do work with one today. In your will, you're going to name your executor. That's the person who will administer your will and act according to your instructions. That person should be a trusted individual, somebody knowledgeable, somebody of high integrity. You will designate who is going to receive personal property of yours, special home items, for instance. In this case, perhaps your second home, your vacation home. You'll also have the opportunity to establish a trust in the will if that is something we're going to explore. Since you're caring for your Aunt Martha, you will want to designate somebody to care for her should you predecease her. This may be one of your sons, though that's something you're going to want to take into consideration and discuss as necessary, but I do recommend that's something that you want to put in your will. In addition to the will, you'll want to write a letter of personal instruction. Typically, this is a handwritten letter. It addresses such things as burial instructions. It's important since typically the will itself is not read until well after the deceased is buried, and it's important certainly that your wishes are carried out. So the letter of instruction is one good way to make sure things like that happen. I also know that you want to minimize probate costs. One of the best ways to do that is to title your properties in such a way that they will not go through probate. And to give you some information, there are 3 ways that you can pass property onto your heirs. First is according to applicable laws, state laws typically, and the best example of that is the joint tenant with right of survivorship registration. Property can pass by designating a beneficiary or beneficiaries. That is a contract essentially. You've done that with your IRA. You will need to revisit that with the retirement funds that you'll be receiving from Jason's estate. And finally, property can pass through a trust. Honestly and frankly, given the threshold that begins to take effect for estate taxation, I'm not greatly concerned in this area. The current threshold is at $5.34 million. So in terms of recommendations on how to title, I'd like to proceed that way to examine how we can best set your expectations properly. Checking and savings accounts. Those you can title as joint tenants with right of survivorship or transfer on death. The joint tenants with right of survivorship registration, I'm sure you're familiar with. That's essentially co-ownership between 2 or more persons who have an undivided and equal interest in that property, in this case a checking or savings account. Assets are accessible to either party at all times. Alternatively, though, you can set up what's called transfer on death registration. This provides for future ownership, meaning that you will designate ownership to transfer only at your death. Thus, you maintain sole access to that account while you are living. It's a very effective means of transferring ownership for these types of accounts. Now, life insurance policy, you have assigned your sons as equal beneficiaries currently. Should that life insurance policy stay in place, then everything is well there. Now, assuming you continue to own Stock A, you can bequeath that in your will as well, like your husband did. Next is your primary residence and your vacation home. These you can bequeath in your will, in which case the properties will go through probate, possibly subject to estate tax, though I don't believe so, or they can be put into trust and pass along that manner. Now, there are other estate planning documents that I want you to consider as well. These will be important as in order to carry out your wishes in the future. There are two power of attorney documents that you're going to need. First is a durable power of attorney, which can be limited so that the attorney, in fact, or the designee is able to manage only your financial matters. This goes into effect typically when you become incapacitated, when you're no longer able to have the ability to act in a legal capacity. The second power of attorney document is a durable power of attorney for health care. And as you can guess, that is specifically focused on the care of your health. As long as you retain the ability to give informed consent, you're in complete control of your medical decisions. But if you do become incapacitated due to a serious illness, the powers allow the attorney in fact, or again that designee, to make medical decisions on your behalf. In most cases, you do want to choose someone you trust, someone who's competent, someone who's caring, and who understands and will effectively carry out your wishes. You may want to designate different individuals for each types of power of attorney. Finally, you should have a living will. This is a separate document. It's different from the power of attorney for healthcare. This is actually a set of instructions that's given directly to your doctor. It tells him or her how to care for you if you are terminally ill. There is no attorney in fact because this document actually contains